Welcome to Solving Citizen Legal Encounters. All right, today we're in Judge Washington's court where we have a pro se defendant who's in court for a debt collection case. There's some things that didn't go right on this case, and Judge Washington is going to address it between the pro se defendant and the creditor.
All right, the court will call the matter of Portfolio Recovery Associates LLC and Shatina Grady. 24C 2622.
Thank you. Good afternoon, Your Honor. Daniel Best, P58501 on behalf of Professional Recovery.
Thank you. Please state your name, ma'am.
Shatina Grady L.
Thank you. All right, the last time we were here on this particular matter was back on May 22nd, 2025, when I granted Ms. Grady L's request to stay this matter and compel arbitration in this case. And it was set for a review today to determine whether she had filed or we were moving forward on the MSD.
So I come today to have my motion for dismissal requested. And
Ma'am, what happened with the arbitration?
So there was no arbitration because that attorney that took the information mysteriously emailed it to the wrong email. I called them on May 23rd, on June 9th, because I had checked my email. If you will recall, at the end of that last court date on the 22nd, the attorney that spoke or sat was supposed to send me information regarding arbitration. I checked the email every single day. There was nothing. On June the 9th, I called to find out why I had not received anything, and I had to leave a voicemail. I did that. I called on July the 1st to find out why I had not received anything and what is going on, because I'm still checking the email. Nobody's called me back. Nobody has reached out to me by mail, nothing. On July 2nd at 8:37 in the morning, they had a representative call me. When I spoke with Kelly at 3:02, finally getting in touch with someone, she said, even though this attorney at the last meeting repeated the email back to us, managed to misspell the email when they sent out the arbitration stuff. So as of today, when I checked, I still have no arbitration stuff, because on the 2nd, when I spoke with Kelly, I gave her the corrected email. I don't understand why this firm is unable to get me the information that I need, either not at all or in a timely manner. I don't understand why, when they can repeat back to me what I have given them per the email, that mysteriously one letter gets changed. So arbitration has not gone through on the failure of their behalf.
Mr. Best, response?
Thank you, Your Honor. I was that attorney. I repeated back the email address that was provided by defendant. I reiterated the E because it was not her last name. I mean, not her first name. It was Shantine, not Shantina. And I got confirmation. I completed the order, and it was an order of stay. There was nothing in that order that would preclude defendant from seeking the arbitration as was ordered by the court. So the email that was sent was not returned undeliverable. We did not have any notice that there was an issue until yesterday when my staff returned the call. Admittedly, we did receive ISHO on June 10th, a call that was misrouted by my receptionist and was not returned. But the bottom line is, at that hearing, the court gave defendant until today to initiate the arbitration. Nothing in that order was needed by her to initiate the arbitration, and the arbitration was not initiated.
So in response to that, at the last court date, I spelled out SHATINA G 317, and I said G for Grady, right? And so you repeated that back to me. First, you asked if it was the E, because in the new name it is SHATEINA. And I said, no, it's not. You asked me, was it going to be spelt that way? Because it's different from what, and I said to you, no, not to that name. We're not spelling it that way. We're not using the E. I specifically said we're not using the E in Shatina, SHATEINA. And then I also said G for Grady, 3. But the email that you sent it to, if I'm telling you there's no E from what you see on my sign-in, SHATEINA, because that's what's on my sign-in, I told you to omit that E. That doesn't go there. We're going to, it's spelled the way that it's in the court papers that you filed suit of. If it's in front of you, you filed suit for SHATINA, okay? And then Grady. And then as to what you sent me, and you saying that the court said that I had to do, if I want to seek arbitration, she asked me, did I know how to do that? I said, no, but I could figure it out. You said, well, I can send an email. Whatever your specific words, which is why I'm getting transcripts printed. I don't know what your specific words, but you cut in and said that you would send me the email. That's when we got to the email aspect of it. That's how we got to the email aspect of it, because I had said, she asked me, did I know how to do it? I said, well, no, but I can figure. And you said, well, I can send, you said, I'll send an email, or whatever your wording was. You didn't say anything about sending whatever you just said that you were going to send. So again, you're playing games, and you're being dishonorable, you're being deceitful. You have not request.
Miss Grady,
Yes.
please stop going down that line.
You know, she's painting that picture, hoping to get that dismissal granted that she was looking for.
I'm just telling
Miss Grady, the
telling
reality is that you came in here and you asked for an arbitration.
yes.
And I stayed this matter and gave you an opportunity to file that. So,
But he also said, when you asked me, Judge, you asked me, and if you needed to run the transcripts back, we could do that. You said, do you know how to do that? I said, no, but I'm sure I could figure out. And he said, as a cut-in, that he has a packet that they normally send out. Nor not I have received that packet, but I didn't receive an email for it. I knew that I would probably not get any response until close to the court date. Like, I knew that. That's why I even called on June the 9th. That's why I even asked if there was a note I could send you at the court. And I was told no. I knew that they would try and do this.
And from June 9th into her hearing, which is in July, she didn't do anything.
That their people called me just now, yesterday. And if the court rules in his favor, I'll just have to appeal it, because there's nowhere have they been honorable in trying to get this squared away. And nowhere that they have a lack of transparency, a lack of due process, because they either haven't given me the stuff on time or not at all for me to present an effective defense.
Ms.
And
Grady,
if the court
Ms. Grady,
understand.
I've adjourned this case, I don't know how many times, to give you an opportunity so that you can be prepared. So
And
please don't interrupt me. Please do not interrupt me. Please.
She's treading on dangerous ground now.
Today we're back here, and I'm not happy with either side. Because one, Ms. Grady, if he didn't send you the information, you could have done what you said you could do, which was figure out how to proceed with the arbitration. And Mr. Best, on this particular case, at each and every turn, there's something that comes up that doesn't go right, which complicates this matter even further. So if she's calling you guys And now with that particular call, it gets rerouted. And like she said, she doesn't get the call back until yesterday. And as far as an appeal, appeals don't scare me, Miss Gradale. I don't mind that people appeal. That's for a higher court to decide if I've done something wrong. But I try to do my best to do the right thing by everybody that comes before me. And I've given you many opportunities. So, Mr. Best, I don't recall the specifics of that part as to whether there's a package.
I have no package, Your Honor. I have no packet. I have, and what I agreed was I would provide the order granting. Or that's what I believe I was agreeing to provide was the order granting defendant's motion.
I didn't
It's
get that.
normally the party who brought the motion's obligation to do the order. My remembrance was she did not know how to do the order, and I agreed to do the order because I have a standard one that we do on these cases. I would never agree to provide legal advice to a defendant on how to file an arbitration.
And that was my thought when this case started. Question for you. Do you think she's straight pro se, or do you think she's sovereign?
I do recognize that my office did drop the ball with respect to the order and getting it to defendant, but I insist that the information I took down is what defendant provided. Granted, we did not properly follow up and we did not properly respond to her voicemails, but it's strictly the order.
And in reality, where we are right now is this court doesn't have an order in it referring it for arbitration or a stay or any of that because the order was never submitted to the court either.
So what I would propose is that we provide, I believe it was 45 days originally. I don't want to keep kicking this out, but we go out 45 days, which would roughly be August 18th. And that she file it by then. I am not providing her any instructions on how to do so. I will submit the order under 7-day.
So we are all clear, Ms. Gradiel. He's submitting the order that says that I granted a stay and that you are to file your arbitration within that time period. It will not say anything else or provide any packet for arbitration. It will be your responsibility to figure out how to file your arbitration. Okay?
I hear you, Judge, but I would ask for a dismissal.
That's not how this process works, Ms. Gradiel, and you can file whatever motions you want to file around that.
I feel biased upon.
Okay, then you can feel however you want to feel about that, and you can file whatever you need to file.
Your Honor, if I can, I'm actually out of town the 18th and 19th of August. I would like to be the attorney who handles this. Could we schedule that either? Yeah, I got a dentist appointment on that Thursday. Does the court hold these strictly on Thursdays?
Strictly on Thursdays, and the 18th wasn't an available date anyway.
Right. The 21st would be the available date. I do have a 1 p.m. dentist appointment, but if we could go, I have a very good dentist. If we can do it at 3 o'clock again, that would work.
We're not here on the 21st. He's not asking for that. He's asking for the next date, the 28th.
Okay, I'm sorry, I'm just wasn't sure if you had originally given that.
No, I did not.
Number of days.
So counsel, you're gonna submit the order granting the stay and providing her with 45 days to file her arbitration. And
Correct.
that be submitted under the 7-day rule. Ma'am, the 7-day rule provides that once the order is submitted, you have 7 days to provide any objections you may have to that order. Court date will be scheduled for August 28th, 2025 at what time, please? 3 o'clock p.m. This is the last date for that arbitration to be filed. If it is not filed, once again, I will tell you, your MSD will be heard that day. His MSD will be heard that day if it is not filed.
And just for clarification of the order, is it 45 days from today's date, 45 days from the entry of the order, or by August 28th?
Let's just make it by August 28th. When we come back here, that arbitration needs to be filed.
Very good.
Thank you.
Thank you. Have a good day, everyone, and a happy 4th of July.
Well, I'm sure that's not the answer that she wanted. And I think my opinion that she was banking on all of this stuff was kind of sabotaging a little bit. And it's something with the email thing, because I didn't see the last hearing. So I'm not sure how all of that got messed up, or she changed the email on purpose. I don't know. But anyway, we'll follow it because I'm interested to see if she's going to file that arbitration, which the arbitration is when they can take it out of court and have their own little private hearing so she can settle the debt. In my opinion, once again, I don't think she wants to settle the debt. She's asking for the dismissal. So it's going to be interesting to see what happens. But let me know if you think she's more sovereign than pro se. I didn't label this as a sovereign citizen video because she didn't really say a lot, but she has a lot of actions with it, but she didn't say much. So I didn't want to mislead on that. All right. So let me know. See you on the next one.